Good morning. We're here on the self-represented family law docket B. I'm Commissioner Dave Nelson.
Yes, Your Honor. Can you hear me? I logged in via mobile, so I'm not sure if you can hear me okay.
I can hear you just fine.
Okay.
Is Mr. Wooldridge here?
No,
I
Your Honor.
am, Your Honor.
Oh.
I think he is.
Him on. Okay.
Last time we were together, we were trying to figure out the status of the GAL report. And so, Ms. Gravina, could you address that initially?
Yes, Your Honor. Let me open my email back up, but I finalized the report and got that out to the parties like 2 months ago.
You had mentioned you did that in February, but there's no report in the court file. That's the trouble that we're having.
Well, I had mailed a number of them off during that time period. So I will refile, I'm assuming then, Your Honor. I didn't know it wasn't in the court report, and I had sent it out, and Ms. Galloway was also on the docket and also received a copy of it. So I just don't have a great answer for that. I wasn't aware. I didn't recheck the court file, Your Honor. I don't have a good answer, and I can just tell the court I am sorry, and I will refile that.
So that's fine. I just want to make sure we get the report in. Ms. Galloway, did you receive a copy of the report?
I did, Your Honor. Yes.
All right. Mr. Wooldridge, did you get a copy of the report?
I have not, Your Honor.
All right. So, Ms. Gravina, I would want you to send one to Mr. Wooldridge also.
Yes, Your Honor. So when we came before the court several times,
yes.
I think it was Commissioner Cotterell.
Yeah, I'm sure it was. Yeah.
But so just a brief history for the court is that there were several appearances with no Mr. Wooldridge. There were then a couple of appearances with Mr. Wooldridge. The court extended my appointment to give him time to participate. I struggled back and forth to try to get documents to him. He did not receive them via mail, nor did he receive them via email. I tried getting new email address and new contact and continuing those appointments. Was unable to reach him for a period of time. We had a number of reviews during that time where I came to the court and addressed those concerns. And eventually the court basically said, go ahead and finish without his input if he's not going to participate. That is what I did. We then came back for the review where I had gotten the GAL report out. The court agreed and told mother that she could file her default paperwork. And that's what my understanding was this hearing was for. And I was coming just to give the court an update that there has been some concern that mother's addressed with me that she's completed the paperwork, but is struggling to find a way to serve father and needed some time and an answer from the court on how to do so. If we don't have a solid address for him or solid email address and no way of getting those documents to him. And so that's kind of where we're at this point after the GAL report and after addressing those concerns. This was supposed to be hearing. The court gave mom, I think, 90 days, 60 days to get the documents to him and come back so that we could hear the motion. But mom does not have a way to serve father.
All right.
Your Honor, I have lived in the same spot for over 2 years now. And Miss Galloway knows that.
Do you know that address, Miss Galloway?
Last that I have on my record is 24. And I also am aware that anytime any sort of certified mail has been sent for him to that address, it has been rejected.
That is the address that I attempted mailing documents to as well, Your Honor.
Were they returned?
Yes. I also sent them via email. Mr. Wooldridge said that he did not have access to that email when he later became involved. We attempted getting a new address and getting that taken care of just to get intake documents. I was able to do about 45-minute intake interview with him, but was never able to get intake documents back from him or anything.
Okay.
And I'm happy to be of help and help progress this. I just don't know the direction the court wants to take from that point. And mother's concerns when she brings them to me is that I don't know how to do this and I can't give legal advice. My answer is let's take it to the court. They'll tell us.
Okay. So first of all, Ms. Gravina, I'd like you to email your report to me also. That would be nelsond@cowlitz.wa.gov.
I can forward you the one and include, I don't have a valid email for Mr. Woldridge, but I do have Ms. Galloway's. Should I include her so that she's in the email as well?
Sure, that would be fine. And Mr. Woldridge, if you want Ms. Gravina to have your email address, you can call her directly. I don't want you to state it over the at the hearing because of we're on YouTube.
Okay. I would need her phone number again, Your Honor.
I think she probably can give you her business phone number. Do you have that, Ms. Gravina?
And he has spoken with me over the phone and via text message. He should have my number.
Okay. Second, in terms of serving Mr. Woldridge, I would invite Ms. Galloway to bring a motion to serve by mail at the last known address. You'll need to indicate in that motion all the attempts that you've made. And I'm not going to guarantee that will be granted, but that's, I think, your next step at this point.
I believe if you look at the clerk's notes from the last hearing, that was approved in the last hearing. But does that have to, I don't know if that has to be certified and he has to accept that. I don't have legal advice to give.
Let me see. I don't remember seeing an order to serve by mail, but I will check the file one more time.
I don't believe that I have put a motion for service by mail. I did speak. I do believe it was with you. However, it has been a while back, so probably not very memorable, about whether or not it was acceptable.
Well, my response is always that you need to make a motion because we need to look at all of the reasons why it should be granted.
Absolutely, I understand.
So I think that would be the next step. But with the GAL report, I guess I'd like to set another hearing within 1 to 2 weeks. That everyone, I'm going to set it the 25th. So that will give Mr. Woldridge an opportunity to file a written response to the guardian ad litem report when he gets it, if he chooses to do so. Okay. And then
And I will be.
Okay. So we'll come back on May 25th then. And then Ms. Galloway, you should pursue the service by mail option and then we'll make some decisions on how we're going to move this whole case forward on the 25th. Good. And
All right, thank you.
And Ms. Height, you're on this case. So last time we were here, Ms. Miranda expressed the frustration of not being able to get in to do the DV evaluation. And I wanted to get an update on where we were at on that.
Yes, good morning, Your Honor. I contacted them again last Monday with this hearing impending. I just reached out to ask for a status, let them know a reminder that this was coming up, to ask where they were at. And my response essentially from them was, we are working as fast as we can and hopefully we'll have it ready by then. I also spoke via phone and email to keep Miss Height updated as well. And again, just that frustration with what's going on with that. I'm not sure, and I was hoping that I would come and appear today and maybe they had filed something with the court to give some sort of update, at least to show some status of where they're at. But at this time, I'm just still waiting on anything back from them. I did clarify with them Again, this was last Monday, just to kind of give them some notice and see where they're at. And I asked if there was absolutely anything else they need from me to get this moving along faster. And then that was their short response. So they did not request any more feedback, information, or paperwork from me. And they said that they're working as fast as they can.
Are you having visits the first and third weekends?
Yes.
Friday to Sunday. How are those going?
They're just fine. I'm enjoying any time I can have, and my son is definitely expressing that, still that he just wants to be with me more, and that's all I'm hopeful for.
Okay. Mr. Estrada, how are the visits going from your perspective?
The visits are going fine, Your Honor. The last couple of times when Sebastian has come back, everything has been really good.
Okay. Ms. Height, any comment?
Only that I share Miss Brander's frustration. She's been really good to keep in touch with me. And as you know, this is a frequent story that we hear. And I'm hopeful that they will move as quickly as they have promised. The response back to her was very brief. Hopefully it means that she's on the top of the pile, but like she said, there's just not that much information. Right now, I think it's vitally important to get it. And so we're just kind of stuck at this moment.
And Your Honor, I did express that to them as well. I informed them, respectfully that essentially with these hearings, that's kind of just what we're waiting on, that other things have been progressing and the holdup is waiting on their report. And again, like Ms. Height said, my responses are very short. They're not exactly informative, but they are responding, which is a good sign. I'm just, I'm kind of frustrated and have concern at this point because I don't want it to appear that I am not doing what's necessary to get things moving forward.
All right. I'm convinced you've been doing everything that you have been asked to do, and these delays have nothing to do with you. Ms. Height's recommendation was that after the DV evaluation, assuming that it is okay, that visits be extended to 5th weekends. And given the delay, I don't see why I should continue to delay that. So you're now seeing the children the 1st and 3rd weekend, about 4 times a year. There's a 5th weekend. That should be based on a Friday. So if it's the 5th Friday of the month, then you would also, I'm gonna also give you that weekend. And additionally, if there's a holiday on a Monday right after your weekend, I'm gonna extend it into that holiday.
Okay.
So that's gonna give you a few days more. After we get the DV report, then we'll see what it says and we'll see if we make further adjustments. But I want to do that now because, as I said, you've done everything that you've been asked to do. This delay is really pretty unacceptable. And I think we need to make that change.
All right. Thank you, Your Honor.
Okay. Mr. Estrada?
Your Honor, we were supposed to address child support. I turned in the pay stubs as requested.
Okay. Ms. Powers is here, so I'll let her address that.
Thank you, Your Honor. The parties both provided pay stubs, but they didn't provide them until Friday. So our office did put together new proposed worksheets, but we did that on Monday. I'm not sure that the court or the parties have had an opportunity to see them yet. I have them ready to argue, but it may be appropriate to set it out since I know we just got them out. I just prepared them on Monday.
It looks like the worksheet is filed with the court. Have the parties seen the worksheets?
I have not personally, Your Honor.
Okay.
No, Your Honor, I have not.
Okay. Why don't we put this out 2 weeks for the specific purpose of addressing child support? And you should receive those worksheets shortly. And if you have a response to it or anything you want the court to be aware of, if you want to file a declaration before the 25th, go ahead and do that.
Your Honor, could you call Cameron Miller and Taylor Young, please?
I see Mr. Miller. I see Ms. Corey. Mr. Camisa, you're here for Ms. Young, I take it?
Yes, Your Honor, that's correct.
And we need to know, is Ms. Young here? We just need to reflect that in the court minutes.
So I have a question about that. If we're on the self-represented docket and she's self-representing, how come is it that those guys are always allowed to speak for her? If we're on the self-represented docket.
So attorneys can appear for clients in this docket.
I've never got anything saying that she was being represented by him.
Have you done a notice of appearance, Mr. Camisa?
No, Your Honor, I'm just filling in to help her.
So you're not her attorney?
Are you a lawyer or are you in?
Yes, Your Honor, I'm an attorney. I'm just filling in to help her. She's actually technically hired a limited licensed legal technician that works in our office.
Right. So,
and given the complexity of the case, I'm just filling in to help.
Right. You have no say here, sorry.
I'm going to let him speak.
So she is being represented how though? Because the legal technician is just a paper pusher.
I understand that they fill out the documents, but it's through a law firm where Mr. Camisa works, and so I'm going to allow him to speak.
Okay.
All right. The last thing I did is I denied the GAL fee waiver on behalf of both people. There was a motion for a revision that got assigned to a judge yesterday. And there were issues with visitation that occurred over the last couple weekends, I guess.
So I got a good question about that part too.
Yeah, let me know where we're at on the visitations.
Okay.
Go ahead, Mr. Miller.
We're still doing the Zoom. Yeah, we're still doing the Zoom. And then the last visitation when she physically seen her was supervised visitation. And that's my most concern. So they were supposed to meet at the grandparents. She texted my sister to have her meet in Grand Mound at Walmart. And I'm under the impression when you're doing supervised visitations, it's with that supervised person and at one location, not out doing a whole bunch of running in errands. And my sister filled some stuff out stating that that's exactly what they did.
Apparently your sister indicated she was uncomfortable being at the grandparents' house. Have you talked to her about that?
Yeah.
So if that's the case, then
Okay, so no, Taylor manipulated that whole thing to my sister. That's how that went about, because Taylor tried to say that I told her 9:30 when that's not what I told her. I told her 9 and to be at the grandparents' house. In the next court date, I'll have my girlfriend submit everything that I stated. Okay, because I stated it is at the grandparents' house. Nobody is to leave. That's not how it works and all of that. You know, I even told my sister she didn't feel comfortable. Well, you don't have to do it. And I'll go back to court and I'll have the judge, what is that? The person that you can pay, I don't know, you pay a facility and then like
that's a professional supervisor.
Right. Okay. But all they did is run around and did errands.
I did read that, but I guess I'm wondering, is your sister uncomfortable being at the grandparents' house? And if so,
she's uncomfortable being around all of them.
Is there another location that we could set this?
No, we can do that person at that, the professional person.
So your sister's out of it at this point.
Yep. And that's just where I want to do it. I don't want no more games. I don't want no more hassle about it. If I have it at the facility, then I know there's just no ifs, ands, or buts about it.
Mr. Camisa, do you want to respond?
Yes, Your Honor. According to Ms. Young, she's reported that Mr. Miller is engaging in conduct that is obstructing her time with the child. According to Ms. Young, the in-person weekend visitations were at the last minute. Mr. Miller changed the location and the time, which is very concerning considering it's something that was agreed to just basically a few days before that. In addition, during the weekly Zoom visits,
I hope you got your facts straight.
Ms. Young was
Mr. Miller, you need to remain quiet while he speaks. Go ahead, Mr. Camisa.
I'm almost done, Your Honor. Ms. Young reports that she was not able to exercise her visitation as the child couldn't come to the Zoom as they were showering after a sporting event. In addition, Ms. Young reports that she gave a photo or a painted picture of the child detailing love and affection that Mr. Miller gave away. The only thing I would really ask is that with Mother's Day coming up this weekend, that Ms. Young be allowed to see the child. However that can be achieved. If it could be done without a professional supervisor, that would be great. But if a professional supervisor is necessary, I would just ask that Mr. Miller bore the costs of it. Or alternatively, the costs be shared between the parties.
So can I speak again now, please?
Go ahead.
Okay, so, I will admit, I put a fan in my room. Okay, there's nothing wrong with that. And I told my daughter to sit down on my bed. So there ain't nothing wrong with that either. And I won't be paying for Taylor to see her child. Miss Young can pay to see her own child. I'm not going to split the cost on nothing about that. And I did not switch the visitation. I didn't switch no meeting spot, no nothing. I texted my sister and I said, if you don't feel comfortable, cancel it. I have no problem with you canceling it, and I'll go right back to court and I'll tell the judge that. So somebody needs to get the facts straight, Mr. David.
All right, I'm not going to have any sarcastic comments on this docket, Mr. Miller. All right.
Well, it's just really getting
Miller,
old with like them saying what they think I said when I know I did never say that. I
All
have
right.
text messages.
I'm ready to make a decision. I don't have anything from Mr. Miller's sister saying that she doesn't want to be involved in the visitation. And consequently, I'm going to assume that she's still willing to do that. I'm going to order a visitation this Saturday from 10 to 2, supervised by Mr. Miller's sister.
Okay, so I need to check with my sister if she's willing to do that right now.
And that can be at a public location.
I need
A
to check with
shopping
my
mall,
sister
a
if
park.
she's
It's going to be a nice weekend. Doesn't have to be at the grandparents' house. It can be at a public location.
okay. And if my sister doesn't want to do it,
Your Honor.
Just a moment. Then she'll have to file a declaration with the court.
who, my sister or
Yes.
Taylor?
No, your sister.
Okay, that could be done.
Ms. Young, I think you wanted to say something. Typically, when you're represented by an attorney, that we have the attorney speak for you.
Yeah.
All right. The drop off on Saturday will be at the grandparents' house, and then the sister and Ms. Young and the child can go, and Malaya can go to another location. Okay. All right. Thank you, everyone.
Your Honor,
Yes, Ms. Corey, please.
this was also supposed to be a GAL compliance review.
Okay, I'm sorry I didn't give you time to speak. You want to give us an update on that?
Sure. Actually, this case I just recently received it. I have intakes out to both parties. I just this morning received Mr. Miller's. I have not yet received Miss Young's intake. Also, I've spoken with both of them and indicated that payment is due this week, and made arrangements for that. Have not seen payment yet, and would ask the court to schedule another compliance review in a couple of weeks to assure that we have gotten the payment process started and that both parties are cooperating.
Ms. Young, I want to encourage you to get the intake paperwork back to Ms. Corey as soon as you can. So I'll see both parties back here on that date. Okay. All right. Thank you.
Thank you.
All right, so we're done.
We're done.
Yep.
All right. Ms. Davis is here.
Yes, sir. I'm here.
All right. So Mr. Clifton, I think I recall from last time we were together that you've actually moved to Minnesota. Is that right?
I'm still in Washington, Your Honor. I have not moved back to Minnesota yet.
Okay. Well, can you give me any? I'm just trying to work with some timeframes here.
Right.
Do you plan to move back, and when might that be?
Yes, I do. So my plan is, because me and my dad, we share a business in Minnesota. So my plan is to move back there, get everything situated to where I can move back to Washington and get my own place and do all that.
Okay.
To take about a month. That's my anticipation, and that is my plan.
So you're going to go back in a month?
No, I'm going to leave sooner than a month. My plan is to be in Minnesota for a month.
For a month.
I'm going to leave in days. Yeah, to go back for a month, and I'm anticipating it will take a month for me to get everything situated. So I have what I need to be able to move back.
Okay.
Your Honor,
Let me finish asking Mr. Clifton a couple questions. Last time we were here, I indicated that you would have 2 visits, and I'm wondering how those went.
So me and Miss Davis just talked about this before court. She was going to bring it up, and I said that it's fine. The 10 to 4 visit on Saturday, it was completely my fault. I didn't realize that I had to work and it didn't pop into my mind. So I will take complete ownership for that, Your Honor. But every other visit that we've had besides that, I would say has gone well, besides just some scheduling issues.
All right. Ms. Davis, go ahead.
Yeah, I was just gonna bring up exactly what he brought up. He, after court this last time, he asked to change the Saturday visit to a Sunday, from like 2:30 to 7, I believe it was. I showed up and he did not, called no showed until about 3:04. He messaged me saying that he was at work, even though he rescheduled from Saturday to Sunday because of work. Then he ended up having about an 1.5 hour visit that day, and then the rest of them have gone really well. I agree with that. It was just that one.
Okay. And have you talked about any other visits between now and when Mr. Clifton goes back to Minnesota for a month?
I was unaware he was going back to Minnesota.
All right.
Yeah. Your Honor, we don't really talk unless it's about our kids. So
Sure.
I guess I've kind of slacked in that department on letting her know about my plans, that I can do better on that. So that's what I have to say about that. But
Do you have time for another visit before you leave? Mr. Clifton?
yeah, I have time for visits. It's just, are you able to hear me?
I can. Yes. So are you leaving?
Okay.
You said a few days. Is that this weekend or middle of next week? Yeah.
Yes. Yeah, that would be this weekend. That'd be either Saturday or Sunday.
All right. Well, it's Thursday.
The only thing that I'm have, I guess, I would request is I got my UA records in, and I got a UA that I did on the 28th in. So I'm just wondering, I'm confused on how supervised visits should still even be a thing. All my UAs been clean.
Ms. Davis, what's your thoughts on supervised visits at this point?
I don't really know. I feel like he has shown that he's, working on being consistent, minus the one situation with this unsupervised. I would probably be okay with that as long as he continues passing his UAs.
Okay.
Oh, there was also one other thing that I did request in court, but I don't think it got put on the order right. So Miss Davis, she did do her UA, but I requested that she be tested for alcohol only because I know that that was why I requested it. And the UA that she took didn't test for alcohol. And that's my only concern as far as my kid's best interest is that there's no excessive drinking and partying and stuff going like that or anything like that going on, because those are things that I have heard that have happened. So that's just my only concern.
All right. Here's what I want to do. If you're around on Saturday, then if you want, you can have a visit on Saturday. I'd still like that to be supervised. And then I want to set a hearing a month from now when when you think you'll be back. And then we'll discuss a different arrangement. I'll probably have you both do UAs at that time, and we'll look at doing unsupervised visits at that point. So do you know when you'll be back, or is that up in the air?
Do I know the exact date?
Yeah, I don't know if you're, if
I
set
do not
this.
know the exact date I will be back from Minnesota at this moment. I don't know.
Okay. Well, then why don't we set the next hearing a little bit beyond 30 days, which would be on June 29th.
Okay. So my visits, so I don't get an unsupervised visit if I wanted it this weekend?
Not this weekend. I want to start those when you come back.
Okay, I got you. Okay.
And so let's set it for June 29th. If you're not back yet, just go ahead and log on to Zoom from Minnesota, let us know you're not back and we'll set it out until you get back.
Okay, and also as far as the child support department goes, I have receipts on Cash App and things like that of me helping Laura with child support that she's asked for. And so I just want to make sure that I have all my ducks in a row before.
Well, Ms.
No.
Powers is here, so let's hear from her.
Thank you, Your Honor. At the last hearing on April 27th, Mr. Clifton said he would call our office to give us an address where we could mail him paperwork. He did not do that, so we still don't have an address to mail our initial pleadings to him. We haven't said anything for child support yet, but we will because the child is on TANF, and so I do need an address for Mr. Clifton. I know the court does not
Can I
like
give you the address now? I tried to send an email because I didn't have my phone bill paid, but I can give you an address if you would like it.
I don't like addresses shared over Zoom and over YouTube. Could you call the child support office and give them the address directly? Okay, we'll be back here then on June 29th. I hope you get your visit in this Saturday and enjoy your trip to Mr. Jones has brought a motion for contempt. I'm gonna hear that. And then there's a couple other things that we need to discuss. Mr. Jones, you want to discuss your contempt motion?
Basically, I just trying to get this over with so I can see my daughter and be in her life. And I just need that restraining order drop so I can do that. Because I haven't seen my daughter in like almost a year.
All right. The contempt order argues that the parenting plan that was entered in this case has not been followed.
Yeah.
And that was entered by default. I think I indicated to Ms. Allwine that she needed to move to set aside the default if she was intended to challenge that, but I haven't seen a motion to set aside the default in the file.
Your Honor, I went to the clerk's office to try to get the paperwork for that, and she tried to set me up with legal aid. And I tried to tell her that you had stated that I needed an order on motion for default and to set aside the default. When I gave her the papers, she told me that I had the wrong papers, that I needed to talk to an attorney first, and she didn't accept my paperwork. She didn't take it at all. And I had served Mr. Jones the paperwork so we could continue this case.
All right, well, it's not in a court file for that reason. Well, do you have any hesitancy in meeting with legal aid?
Mr. Jones has sought out legal aid around here, so I've been having to get online to answers.com through an attorney that I paid to get answers and whatnot. So I have the papers right here.
Okay. Every Monday at 2 p.m., we have somebody at the courthouse that can assist you. Have you attempted that?
Yes, I was on the list and they said that they could not help me due to the fact that it was a conflict of interest because Tyree Jones has already sought help there. I've actually sought out to to 3 different legal aids around here, and I have been told no. So it's been frustrating. She gave me this paper. Where is it at? She gave me the chart notes from the last time we met. Right here, it just says that Ms. Allwine needs to bring a motion to set aside the default. But she wouldn't accept the papers, which was really frustrating because I was like, well, this is what I need. And she's like, I think you need to talk to legal aid first because I don't know if she was confused or whatever, but I have the paper from the clerk, what she gave me. And I signed up on the list for legal aid and they told me no. And I already knew it was going to be a no because I've already sought out that help. So I will try to refile it today before I go to work.
Well, here's kind of the state of the case right now. The court has entered a default, and that wasn't, let me just see who it looks like Judge Basher entered a default in a final parenting plan. The parenting plan gives Mr. Jones primary custody with visitation to you on Friday through Sunday.
Right.
Mr.
And I-
Jones is saying that he hasn't seen his child in a long time.
Correct.
Technically put you in contempt of this particular order.
Right, but there's been a restraining order keeping him from Kalia and I. And I did a good cause hearing. I asked for there to be, consider a new parenting plan due to the fact that I was never served the parenting plan back in August or last year. I never received a copy, so I never was able to appear in court. Or I would have been there, I wouldn't have been.
Well, and that's why I'm trying to have you bring a motion to set aside the default.
Okay, so I will be in there to set aside the default. I've already entered the new parenting, or I've tried to. Tyree's been served the new parenting plan. I don't know if he wants to sign off on it or not. But
What's
I will,
the new parenting plan?
where I have custody and Mr. Jones is able to have her on his days off or on the weekend, whichever works. And then he has a peer support counselor and where we could communicate if we had any issues with deciding or having any conflict, that we just communicate through his peer support counselor if there was any issues. But my daughter does miss her dad, and I do want them to be able to be reunited.
Until we work that out, is there potentially somebody who could supervise the visits with Mr. Jones?
I believe I don't know if his ex-wife or even his peer support counselor. I'm fine with that.
Mr. Jones, any thoughts on that?
Right now, I got my peer support. She can help me out if it need to be.
Well, I'd like you to see your daughter, but until we sort out the issues in this case, I'd like those visits to be supervised. I'm not saying that's going to be the case forever, but initially I'd like them supervised. Do you know when your peer support counselor would be available to do that with you?
She's right here.
I can schedule it anytime.
Okay, thank you for letting me know. Ms. Allwine, what would be convenient for you? I'm looking for a 4 to 6 hour time slot each week.
Anytime before 3 p.m. I said I work swing shift, so any day of the week before 3 p.m.
So like something 9 to 2?
Yeah.
What day of the week would work for you and your peer counselor, Mr. Jones?
Do it tomorrow? Let's do tomorrow.
Tomorrow?
Yeah.
So then I'll set it on Fridays. I'd like this to be consistent.
Okay.
All right. And then where can the drop off be? I'm going to assume the drop off is going to be to the peer support counselor.
Yes.
Yeah.
Courthouse.
Oh yeah.
I missed it.
Where will that be?
If she could bring her over to the support center in Longview, we're at.
Okay.
That'd be great.
Awesome.
All right. So we'll start those tomorrow, 9 to 2. She's got to go back to Miss Allwine right at 2 o'clock.
Right.
And we'll have those on Fridays. I'm going to set this out. Let's go 3 weeks to try to get the default motion to set aside default paperwork in. That means there will be Friday visits on the 12th, the 19th, and 26th.
All right.
Okay.
Okay.
Thank
All
you.
right. All right. We'll see you back here. All right. Let's go to Garrett Alton and Ashley Keefe.
I'm here.
I'm here.
All right. Good morning.
Good morning.
And Ms. Call, are you with us? There we go.
I am. Good morning, Your Honor.
All right. I think I want to hear from Ms. Call first, if you've been able to contact the parties and talk to them, and then we'll go from there.
I have. Both parties have paid their portion of the gal fee and turned in their intake paperwork. They've both been properly communicative. I have home visits scheduled with both of them on Friday. And I'm also looking forward to meeting Kiddo on that day as well. So I'll be in to do a home visit and get to interview all 3 of them at that point in time. I was able to.
Tomorrow,
yes,
Friday.
Tomorrow,
Okay.
Friday. Yes, thank you. I forgot tomorrow's Friday already. I was able to receive some added information from Mr. Alton that he wanted to share with me, documents, things like that. I've been reading through the case file, read through both intake documents. So we're well on the road.
Okay. And it looks like there's phone calls that are supposed to be happening. How have they been going?
He only messaged him the day of court and said, "I love you," and Landon didn't respond, and he has not reached out since then.
Okay, let's hear from Mr. Alton. Go ahead.
I've reached out a couple times and I messaged him on Facebook because he doesn't have a phone, and the messages get read and there's hasn't been a reply.
Okay. All right, I think what I need to do is wait for Ms. Call to finish her report before I'm able to make some additional decisions in this case. I'm going to note that in looking over the file, I am concerned about the status of Landon's education, and I think that needs to be looked at and explained when we get together again. Okay. I'm going to allow Mr. Alton to continue to reach out to Landon, but if he doesn't respond, then I don't know if there's I can require that.
Your Honor, can we request that Mr. Alton use one of the family apps that would allow him to communicate and have those communications recorded, or even allow me to observe?
Which one, or do you want to name
Family
it?
Wizard. Yeah, Family Wizard would be great if that's an option.
Yeah, I have that one.
Okay. Mr. Alton, could you get Family Wizard on your phone and then use that to communicate?
Yeah, I think that's a better option for sure.
Okay. So, Ms. Call, how long do you think you'll need before your report will be ready?
I think we're on schedule to have the report done on time. I don't think we're, unless something comes up in the investigation in the next couple of days that makes that difficult. I think and the things, what I've informed the parties of that helps a lot is if they have things like school records, if they have things like, I have access to the court documents that have been filed, but if you have access to CPS reports, things like that, because those things can take a while to come and to be delivered, that can extend the issue. But if you're able to provide me with those things, then it keeps us on track timing wise.
All right, I'm looking for the order of appointment. So I indicated a final review of June 29th. Does that still sound realistic?
As long as I can get access to those reports, particularly the school reports and the CPS documents. I understand there was another guardian ad litem report written for another child in the family, and I'd like to be able to read through that as well. As long as I can get access to those documents in a timely manner, I don't see a reason why we couldn't have the report done on time.
I can send you those.
Okay.
Okay, good. All right, well then the next hearing will be June 29th. And Ms. Post. Ms. Post has brought a motion to restrict abusive litigation. Mr. Cave, are you ready to proceed with that motion?
Yes, Your Honor.
All right. All right. Ms. Post, I'm going to let you tell the court why you would like that order entered.
I don't know if you remember that we were recently in court for his protection order that he had against me, or
I did look at that
but I had
file,
against him.
so I am somewhat familiar with that case.
Okay. The issue that I have had is how many times Jared has threatened to use the court system against me, including what he has already done. In his response, it stated that he was not using abusive litigation because he has only filed one thing against me, which was the protection order. However, considering the situation, if you take a look at the events that have happened, there was the domestic violence case and then the protection order. And then he had threatened to use the court case again, or the court system again, to take the house away from me. The domestic violence case, yes, he was not the one who filed it against me. However, he is the one who made the call, despite claiming that he was worried about my mental health. If he had truly been worried about my mental health, he could have called the crisis line or requested the ambulance or informed them that it was a mental health issue. But in the recording to the operator, and I was there to hear this, he did tell them that, no, it is not a mental health issue. No, she does not need the ambulance. Like I said, if he had actually been worried about my mental health, he wouldn't have called the police or would have gone a different route. So while his was not direct, it is his way of using the court system against me. And then directly after that was dismissed, he put the protection order on me. He later had the protection order dropped. And the exact same day that it was dropped, within an hour, I had gone home and he had presented me with an ultimatum of, take 15% of the equity whenever he decides to sell and take my name off of the house, or he was going to force me to do it through courts. Later, he suggested that I take my name off of the house as long as, or not as long as, but if I was willing to sign a lease to live there. Both to me were quite insulting. And like I said, the issue that I have is that he is trying to use the court system in a manipulative way to get or to keep control over me.
Okay, thank you. Mr. Cave,
Yes, Your Honor.
any response?
Absolutely. Factually, I've only filed one piece of litigation against her, as opposed to what she deems as threats to the house. We are no longer together. She is in fact married to another man. So my intent is to settle the house. So posing that we negotiate the house, and if we cannot negotiate that, then we will have to let the courts decide, I feel is kind of the only two options we have. Not necessarily something that I'm trying to threaten. And I'm sorry she's taking it that way. But we do need to figure out what's going to happen with our shared assets so we can both move on. And if we can't come to an agreement with that, then we'll have to let the courts decide.
It was threats. My mother was there to witness it. In fact, originally he had stated that he did not want any witnesses to what he had to say. But I refused to speak with him until I had a witness, which was my mother. Yes, we do need to determine the house. That is obvious. My concern was that during the court case, during our discussions electronically, we had agreed to cohabitate. There were reasons why I'm not living with my husband, but we had agreed to cohabitate, and that was open-ended. It was the same day, however, that the protection order was dropped, that he immediately jumped to threatening me with another court case if I didn't give him what he wanted, which was the house. I understand that we do need to go to court for the house, since we apparently cannot cohabitate. But the thing that upsets me is the fact that he lied about being willing to cohabitate. In fact, we had discussed during those electronic communications that I would set up the living room as my bedroom, and he would take the bedroom that was originally something we had shared. When I did come home and tried to set up the bedroom, he stated that he could not have me do so, that I was not to I was not to make my own space in the home because I wasn't going to be there very long. I went ahead and made my own space in the living room because that is what we had originally agreed upon.
All right, let's address the motion to restrict abusive litigation. There's a balance that the court needs to strike. On the one hand, the court should be open to individuals. So if they have disputes, they can come to the court and resolve those matters. On the other hand, we don't want the court system being used or threatened as a sledgehammer to threaten people. And that's the tension that we have in this motion. Mr. Cave has filed one domestic violence case and ended up, I think, asking the court to dismiss it, which happened. And apparently there were some threats. I'm going to take you to court. We'll go to court over this and that. It looks like in response to that, Ms. Post filed her own action for what we call a committed intimate relationship, which, if established, would allow the court to adjust the property rights of the parties.
Yes, Your Honor. I felt that his offers to either take 15% of the equity whenever he decided to sell, or to have me sign a lease to live there were quite insulting. So I felt that, yes, we did need to go ahead and have the courts decide what to do with the house.
And I think that's appropriate where there's a dispute like that. Filing the action that you did is something that should be encouraged. I'm not condoning the threatening language, but in terms of just looking at the litigation that's been filed, it hasn't reached the stage of being abusive. The statements may have been, but the actual litigation hasn't. Let me say this: there should be no threats at this point, because all of your property issues are going to be determined through the lawsuit that's on file. And you may, in a formal setting, sit down and see if you can settle it. But anyway, the two reasons I don't think I can grant this motion at this time is, one, I haven't seen an extensive filing of lawsuits that would amount to being abusive. And second, what needs to be resolved between the two of you is already part of the lawsuit and can be handled in that setting. If there are threatening statements made after today that are concerning, then Ms. Post will have the ability to file for a protection order that would restrict any contact, except maybe in limited circumstances. I hope that doesn't happen. I hope you just address the property issues of the existing lawsuit. But for those reasons, I'm going to deny the motion at this time. It's without prejudice to rebring it if you feel that there's been a filing that does amount to abusive litigation.
May I ask a couple of questions?
Sure.
The first question is, what would be considered, filings in order to be considered abusive?
That's hard for me to say, and not to avoid the question, but one of the things that courts do is they don't give advisory opinions. They only make decisions when in actual cases before them.
Okay, and then my second question, you may have just kind of answered it, but let me just go ahead and ask it anyway.
Sure.
In our previous case, you had stated that I could refile the protection order with the recordings that I had of Jared. How would I go about? I mean, is that still an option? How would I be? I don't even know how to get the recordings submitted to the courts.
The clerk is probably not going to take those. You could refile and bring the recordings to the hearing in a form that the court could either listen to or review. Those would need to be provided to Mr. Cave.
Okay. The recordings that I had, not all of the recording was of him specifically, threatening things. Some of it is just like me talking to my dogs or such like that. Am I able to just pinpoint in the recordings where it was a problem?
If you can identify the exact location, that would be very helpful.
Okay, I will work on that. Thank you.
Okay. All right, thank you. I'm going to deny the motion, and hopefully you can resolve your issues through the existing. All right, I did see the response filed by Ms. Bierbauer, so I'm going to give everybody a chance to discuss with me what they'd like to see going forward. And maybe what I should do is let Ms. Height speak first, and then we can respond to her. Okay. Ms. Height.
Thank you, Your Honor. I filed my report after my investigation, and I guess the most cogent way to start would be to say that at the end of my report, I make the statement that I'm tasked with answering the question, what is in the best interest of these children? And further to say that I understand that this is a major change for this family and that it's going to be upsetting probably for everyone involved. But I feel like this report reflects accurately my reasons for considering a major change of residential time. I think the concerns that I talked about in there, basically swirling around the home setting with Mr. Williams in it, are of such concern that it seems like that is going to be the best. My recommendations of changing primary residential time is going to be in the children's best interest. And I don't know how much, there's quite a lot there. I don't really want to go into every bit of it. If there's a listing of things there that everyone's been able to see. I guess I want to acknowledge that I know this is difficult, and it was a difficult report to write, and it was after a lot of consideration that I came to this point. Once I got there, it feels like it is definitely in the children's best interests. A couple of things have come my way unsolicited since then. I've had 2 phone calls from a neighbor who was quite reluctant to talk to me for fear of some kind of blowback. This neighbor very vividly described hearing, she recognized which child it was, who was saying, she could hear through the wall him hollering, "No, no, stop, stop, someone please help me." And she called me wanting to know what she should do about that. And it had had already stopped. It has ceased. It was something that had happened, I believe, from my notes on April 27th. And so my statement to her was, if you feel like there's something going on that is endangering to a child, then you need to call law enforcement. At that point, at that moment when I was talking with her, nothing was going on. But she said that she has heard a lot of upset there. And that was concerning and sort of verifying to some of the other mentions of Mr. Williams hollering. She said that's who was yelling at a child. So that kind of underscored the things that I had come to believe would be in the children's best interest. In addition, in also, which I had a copy of, a statement in writing that Ms. Bierbauer said about Mr. Bierbauer. I'm reading from page 3 of temporary parenting plan from 2016. Jeff has always had a loving relationship with the boys. And then further down, Jeff keeps the children safe and protects them. So while I recognize that he has had less opportunity to care for the children and be involved on a day-to-day basis due to the current parenting plan, I do believe that he's capable of doing it. He's willing to do it. He has support system in place. So that's on one side. The other side is Mr. Williams is very enmeshed within the family. When I saw them together, he is helping out with schooling. He's correcting the children. I believe that I described some of that for your honor. He is definitely a very important part of the household. And I find that because of his past and because of the short time that he has been around, that I am not confident that he is a safe person or that that household is safe with him in it. And in fact, you'll note that I don't believe that he should be present during visitation with mom. So that is kind of in a nutshell where I landed and why I did. And I would reiterate to you again, I understand that this is a big change, but my concerns rose to the level to recommend that change.
All right, thank you. Mr. Bierbauer, anything you would like to say?
Not really, but on like the past is my past, as what Ashley has stated in the report from 2016. That's done. It's over with. I'm more worried about the present and the future and the safety of my children.
Mr. Hawkins?
Yeah, I would just like to talk about 3 things. The first is what the report didn't consider and what we addressed in the response is that there has been instances of prior abuse from the petitioner, including accounts of rape, one which took place in earshot of the children. All of this resulted in a restraining order. And from what I understand, the petitioner has not denied any of these allegations at this point. And so it's concerning to us, and especially highlighting what Mr. Bierbauer just said, that he's not concerned about the past is behind him, he's concerned about the present. And we find it interesting that you'd be holding the past against my client's boyfriend and not considering his present state while not doing the same for Mr. Bierbauer. We'd also just like to note that in regards to concerns about schooling, in the response, we noted that they are on track with their 12K online plan. And to the second point, I think this is not in the best interest of the kids. Like I very much respect Ms. Height and the report she put together, and I understand the amount of time and effort that goes into this and how hard this can be. But we see this as a massive upheaval that disrupts their schooling and their social lives. And petitioner has not yet shown the ability or willingness to perform these daily tasks for the kids. And given his work schedule and the needs of the kids, including medical appointments that are every 2 weeks, every 2 weeks with a counselor, every month with a psychologist, and other regular appointments, we do not feel he'll be able to provide for those. Along with just the daily needs of taking the kids to school and picking them up from school and providing the care that's needed there. I don't think we have an idea of what kind of plan is in place to fulfill that. And so I think we seriously doubt whether that can happen. And third, I would just point out to this first point again of there are current precautions in place with the mom living there. Currently, the boyfriend is not seeing the kids on his own. He's not being there alone with the children. And additionally, as Ms. Height noted, there have been no allegations by the boys nor any whispers of impropriety going on there. And so I just think it would be in the best interest of the kids to maintain this status quo. And I respectfully understand these concerns, but I think the concerns of making this change are equal to those. And so it doesn't make sense to me to make any change at this time.
Okay, you have it she had it listed that I work 5 to 5. I do not work 5 to 5. I'm usually off work by 3, 2:30, 3 o'clock, 3:30 at the latest. And she knows that. And on the medical stuff, I have asked her actually numerous times to let me know. And she does not inform me. She has not asked me to be to them in over a year and a half since we've been separated. I
Hasn't asked you to do what for them?
To go to any of the appointments,
Okay.
the medical appointments, and she has not informed me of any of them. And I have my father here that can pick them up or drop them off and pick them up at school. And I'm pretty sure I can get time off to take them to appointments.
We just like to again repeat that there is concern over the regularity of the appointments needed. It is not conducive to that kind of work schedule. And so just asking for time off seems not a workable solution. Again, when historically that hasn't been the case. And again, historically, my client has asked him to be involved and he has not been. And I think that leads to this pattern of not asking now because he has shown a lack of interest before then.
I have no text messages or phone calls from her letting me know when appointments are. None. I save all of her text messages and phone calls. I do not delete them. I have none.
All right. Ms. Height outlines the criminal history of Mr. Williams, starting in 2008 with rape in the 3rd degree, child molestation in the 3rd degree, and rape of a child. That was in Cowlitz County. And it goes on until 2019 was possession of a controlled substance, 2019 unauthorized use of a vehicle. Apparently in 2019 was the failure to register as a sex offender where he resulted in 3 years in prison. And there is no criminal history, I guess, after that, which is likely because he was spending that time in jail. And my understanding is he went directly from jail when he got out after 3 years into Ms. Bierbauer's house. And is now, as Ms. Height said, integrated into that household. So the first thing I want to say is that the criminal history isn't ancient. It's up until what I would consider present day. And it is a history that the father is legitimately concerned about, and Ms. Height is legitimately concerned about, and the court is legitimately concerned about. So that's the first thing. The second thing is I want to tell you how I viewed this case. making a major change for the children places the burden on the children. What's going on here is we have somebody with a very concerning criminal history, and I think a mother who made a bad decision to bring this person into her household with her young children. The burden of that should rest with Mr. Williams and Ms. Bierbauer, not with the children. And I think the way that that gets handled is this. I'm going to do this in two time frames. From now until June 15th, which is just for my purposes, the beginning of a summer, I'm going to leave the same schedule in place. So the father will have the children, I think, every other weekend. But Mr. Williams must be absent when the children are with the mother, which means he's going to have to find somewhere else to live. If Ms. Bierbauer wants to spend more time with Mr. Williams at the house, then the children can go to Mr. Bierbauer more often. But Mr. Williams must be absent from now until June 15th when the children are at Ms. Bierbauer's house. Starting on June 16th, which is a Friday, I'm going to order that the children spend 1 week with one parent and 1 week with the other parent. And so that first weekend, the transfers I'm going to order are going to be Fridays at 5. So June 16th at 5, the children will go to be with the father and will stay with the father the next week. And that's going to be the schedule during the summer. Again, the week the children are with the mother, Mr. Williams cannot be there. I'm going to order a review hearing on August 24th. And the issues at that hearing will be what contact, if any, the children should have with Mr. Williams going forward. Second will be what kind of schedule between the parents we should adopt. And third will be what kind of schooling they're going to receive. I think transferring the children to Mr. Bierbauer and having them enrolled in school for about a month with special needs kids strikes me as being pretty disruptive to their lives. And that's why I'm not going to order that. However, if I'm not convinced that there's a good homeschool program put together by Ms. Bierbauer, which will include testing and evaluation of the children, then I may well place the children with Mr. Bierbauer starting next school year so that they can attend school where he lives.
And I have the paperwork to enroll them in school. I have it filled out. I just have not turned it in yet.
I'm going to give Mr. Williams, well, is this your weekend, Mr. Bierbauer?
Yes, I will pick them up tomorrow at 5 o'clock and bring them back on Sunday at 5 o'clock.
All right.
At the Fred Meyer parking lot.
I'm going to order that Mr. Williams needs to be out of the house by Sunday before the children come back. And if that's not possible, then there needs to be a message to Mr. Bierbauer that he should keep them until Mr. Williams leaves.
Okay, so he's allowed to be there until, okay.
He's going to be there tonight and until you pick him up tomorrow. I don't know that that process can work faster than that, but he needs to leave by Sunday. All right. Let me go around. Ms. Hyde, any questions about that?
No, I don't have any questions. I would just like to comment on the schooling. I felt exactly like you did, as you just stated, that it would be very disruptive. And I spoke to a special needs master's level educator about what options would be best. And in fact, it surprised me that this person said that they felt like having the kids go have some time in school for a short term as kind of a transitional time, and then going into summer would actually be in their best interest. So like I say, I was surprised to hear that, but that's why I included that in my report. That was from somebody who is a pretty high level expert in the field. So I just wanted to drop that information in.
Part of what entered into my thinking here is the children have been with Ms. Bierbauer for their daily care for quite some time.
Correct.
And I view the week on, week off as a transition time if we need it. So.
Oh, yes, I think I understand and appreciate what you're doing. I just wanted you to know where my thinking had come from on that.
Thank you. Mr. Bierbauer, any questions?
Not right now, Your Honor.
All right, Mr. Hawkins.
Just can I get the date again for the review hearing?
Will be August 24th. It should be a Thursday.
Okay.
I'm assuming school is going to start the first week of September. And so I want to have a hearing to determine what we're going to do at the beginning of the school year. And that would be a natural transition to look at the visitation schedule.
Okay,
All
so
right.
will that, Your Honor?
I will.
Be,
what's that?
Will that be via Zoom or in person?
That will probably be Zoom. I think we're going to be on Zoom for quite some time. Okay. All right. I'll put a bench order together. Should be available by Monday, but again, Mr. Williams will need to be out of the house by Sunday.